amazing life won't define who he is and what happens to the rest of his family over the coming years. Thank you for listening.
Nathan Sherwood, thank you. That would be our final witness.
Okay.
Go ahead, come on in, sir. I apologize. Go ahead and come up to the podium. Thank you. Lots of moments. Okay, thank you, Madam Clerk. If you could tell us your name and what would you like to say today?
Absolutely. My name is Nathan Sherwood. I am the brother to Lacey Rawlings and brother-in-law to Daniel Rawlings. I've known Daniel for 25 years. We moved up to the White Mountains in junior high. He was the one that first approached me on some Boy Scouting outings. Be able to become good friends. We had very similar core values of our family. We love family. Family meant a lot to us, both in the love and the compassion, but also to the defense of them. And we shared that, and that became to be an aggressive bond between us. Far before he met Lacey, we were very good friends. We did sports together. We both went on missions on the same time, and upon coming home at the same time that he was marrying Lacey, I was marrying my wife. In 2011, I lost my brother. The Sherwood family lost their brother and their son. And it's sad, but actually today is his birthday. And I remember the date because it gained so much more respect for Daniel in regards to our family. We were in a state of chaos, a disorientation, not knowing what to do or how to deal with my brother's loss. It was Daniel that had the sound mind, competent, level-headed, figuratively and literally bringing our family together. He was pivotal in helping us organize the funeral. He personally dug the grave. He was specific in building my brother's coffin. I share the same thoughts as Jay in regards to having the opportunity to live and be with your hero here upon this earth. With the loss of my brother, Daniel stepped in immediately. Has always been there in the moment that I would need him. We were able to go on vacations quite a bit. Specifically, we've gone to Lake Powell. It's been one of the greatest annual trips that we get to go on vacation. One of the neatest things that I saw the first time that I got to go is Daniel brought everyone in when everyone arrived at the houseboat, and he sat everyone specifically down and basically did a safety meeting in regards to, hey, these are the do's and don'ts. Never go outside the houseboat without a life jacket. Don't go on the back of the boat when the generator's running for the carbon monoxide. And not only would he engage in the beginning, he would talk to the adults the same as the children. And even at times when we would set up camp, he didn't mind enforcing those rules and help re-educating. And that's always been his demeanor. Every time that we've gone on camping trips, every time we've gone, there's always a plan in his mind. There's always a time that we sit down and engage and talk about the events. That's just his thought process and his mind flow. To always be safe to his family and mine. I've always wanted to go on trips with him, regardless of where we go, because I'm able to trust that everything's going to be okay. 14 years ago, We had children within similar years. And that's been probably the most beneficial thing to see and to grow up with him, to have children of similar ages, to be able to call, engage, and counsel. I've sought his counsel many a times for who he is, to seeing of his engagement with his children, not so much only his love for them, but more so their love for him. I feel very inadequate today, not only to being able to speak to the character of this phenomenal man. I don't know if I have the words. I know that I don't have the words. And not only me, but there's thousands behind me that would say the exact same thing, that share in the common belief that he is sincerely their brother in any aspect that they could call at any time, day or night, and that he would be there. You know, I've had the privilege of serving in the military. I operated as a reconnaissance sniper, and I not only operated on multiple missions, but I also got to train many of our soldiers in being able to evaluate both their physical and mental capabilities to be able to serve in the most elite operations in this world. I know for me and in this life, there's no one that I would want by my side more than Daniel Rawlings, to the caliber of who he is, who I trust and I love, who has the mindset of safety in all things, in all aspects. I plead with you. His family needs him. His wife needs him. And selfishly, Your Honor, I and thousands of others need him. Thank you.
Mr. Griffith, I'll hear from you now and/or your client, and whoever's speaking, if you could just make sure you're close to a microphone.
Dan Rawlings will address you.
Mr. Rawlings.
Your Honor, I'd like to thank you for the opportunity to address you today. First and foremost, I want you to know I take responsibility for the actions that occurred on November 19th, or November 29th, 2019. There's been many nights that I have laid in bed wishing I could go back and do it again, but that's not possible. Just isn't. I am tremendously sorry to the many people that I have caused pain. I have not seen Lauren in a very long time. And my heart goes out to her for the pain that she still suffers as a mother. And I'm sorry. I wish I could take that from her and carry it myself. I wish I could take everybody's pain and ball it up and hold it myself, because nobody deserves to endure the pain that I caused. There's many in this room and outside the courthouse that have come to support those involved in the accident. Me, my wife, my children, Lauren, my nieces, my brothers. And I'm grateful for that. And I'm grateful for the community in which I live in. I get to be a part of such an amazing community that will stand behind me. One that I get to work in every day, and one that I get to serve to when I am able to see something like that. On the day that I became a father was one of the greatest days of my life. I realized the importance of raising a child. And I'm grateful for the parents that I've had as I was able to grow up, the values that they instilled in me. Honest and trustworthy, loyal, obedient. Those are the same values that I try to instill in my children. Me and my wife worked so hard to do. I have an amazing family. My wife is everything to me. She stands beside me as I do beside her. children in a way in which they will be able to contribute to society. That is something that I find very important. You need to be able to contribute to society. And I believe that my children do that very well. I believe that my wife and myself also do that very well. Again, I wish every day that I could go back and relive and redo the events of that horrific day. It's not possible, but what I do every day is I relive. It's pain that is unspeakable. I can't describe it. I look at my home and I see a picture of my family, what we once used to. And you know that I was a single cause of the reason why it is not anymore. It's what I live every day. Because of elections, Lauren lives with it every day. Jay lives with it every day. The children, my wife, my children, all those that are affected live with it because of my single decision. As you heard today, Your Honor, I don't believe that a single decision is what defines me. I will live the rest of my life trying to reverse that defining moment. Trust is a very important thing in my life. My father taught me at a young age that, he always loved me. He would use the phrase, I don't trust you right now. And that resonated with me because more than anything, I wanted my father's trust. More than anything right now, I want people to be able to trust me again. For the rest of my life, I will live in such a way that I will gain their trust back. I appreciate you taking the time to listen to me this day, and I would ask that you would see fit that I would be able to serve a term of probation, and I'd be able to continue to be bound with my family. In the community that I will continue to be able to serve.
Judge, thank you. We're late in the day. I'm going to try to just pull some threads together from everything that we heard today. Because I think that's your job, to consider everything and put together how to resolve what I would tell you is just an extraordinary situation. It's an extraordinary case. It involves extraordinary people and an extraordinarily unfortunate event that occurred a couple of years ago. Your course of life, your course of conduct determines, I think, oftentimes how you get perceived and how you should be judged in a moment of difficulty. You've heard from hundreds of people and from a dozen people today about the quality of parent and individual that Dan and Lacey Rawlings are. I want to focus on just a moment before I talk about extraordinary, about the irony of this situation. It is just unbelievably ironic and unfortunate that a person who is over and over and over again characterized as cautious, and safe, and careful, and reliable could be in this position. It just isn't. It isn't who he is. As you heard described, this is the guy you want to have be your neighbor. This is the guy you want to have in your community. This is the guy you want to have leading your company. This is the guy you want to have leading the Scout Night. Because that's who he is, and that's why he gets all the accolade and support that has flown here. The amount of response to this case was extraordinary from the get-go. The day after this happened, there was an extraordinary response of people who came to help and search. They got in law enforcement's way. Law enforcement found a way to deal with it because there's no way to turn them back. So they used it instead of not using it. And I appreciate that. What I'm hoping today is that the Reds will come around and that law enforcement, prosecution, people out in the street that don't know all the details and full story will understand how an extraordinarily unfortunate situation can, in this unique circumstance, result in an extraordinary outcome. An outcome that embraces not just the concept of accountability, as some witnesses called for, and not just the concept of justice, as some witnesses and others have called for, but a way to come to a resolution of a tragedy, but a crime that still can find construction and positive rather than destruction and negative. I'd ask that everybody just for a moment stop. Look at this man. You see a man who's in a foxhole conversion of remorse. Every day he deals with this. I've talked, I know, we've heard from everyone how...
I realize you...
I'm sorry.
So to make it, I have folks...
Don't lose the communication. Thank you. I just hope that everybody appreciates the courage and the shame that is blended into the soul of this guy. It's just simply extraordinary. Having said that, I want to turn to what I think is even greater demonstrations of courage. Lauren and Jay, just tremendous what they've conveyed to the court in terms of their heart, their understanding and their compassion, and what they'd like to see happen here today. When I talk about constructive, I suggested in my memorandum to you that community service is really the strong suit of Daniel Rawlings. And I suggested something that might seem corny, but that he be used in a way to get the message out to the community, what happened to him and how the tragedy unfolded and what it meant to the community. Public service announcement, however you wanted to use him. But he is a respected voice who commands attention, and the story about this case can be a learning tool for everyone. We talk about it over in my office in Flagstaff. We talk about it as the Rawlings reflection. That moment that Daniel didn't take that day, that Daniel and Lacey missed that day, that they will never miss again. That moment of reflection about, it's fun, we're having a good time, this is Thanksgiving, we love our family, we're bonded, we're having a great time. Not goofing around, we're having a great family time. And they missed it. They missed the danger that they thought that they were on top of. This wasn't an impulsive call. You saw how they crossed the creek, careful and slow, with a vehicle that was designed for, high clearance and tough stuff. And they thought that they had some experience to be able to handle that, because it was easy peasy, as Bond said. They're wrong. Where they made their mistake is trying another cross. And the state's position that it was without emergency and without need, and it was unnecessary and it was gratuitous, 100% true. 100% true. But it was family, and it was a great day. Day after Thanksgiving. And so, did he miss the difference in the two crossings? He did, because he never crossed it at Bar X. Never. Did he understand the difference in depth and the difference in the situation? He didn't. He didn't take that Rawlings reflection that is the hallmark of his life and how he's conducting himself. And he missed the fact that there's a hydraulic, a subsurface situation there with a hole that he parked that vehicle in. And he missed that. But having said that, that's all about accident. And I want to concede, I hope everyone understands, we don't shy away from the understanding that there was more than just accident here. It was accident plus. It was an accident based upon misjudgment and misperception. But there was a mistake made, and that was to disregard the plus. What makes this criminal is that he ignored the signs. He ignored what our government, what our authorities tried to do, to tell him, you don't know more than we do. You're not safe. Don't do it. There's a corny sign at the crossing, and it says, turn around, don't drown. That sign's there. And we missed it. Because we're having a good time. And that's the irony and the tragedy of this case, because Dan doesn't miss those things. As you've heard, he doesn't miss them with his family. He doesn't miss them in his community. He doesn't miss them when he's leading the scouts. He doesn't miss them when he's training our children in athletics. He doesn't miss them. There's a movie. Dan and Lacey are sports people. There's a movie, Remember the Titans. There's a line in Remember the Titans because one of the star players gets hurt, gets paralyzed. And the coach is asked about what that means to the team. He says, you can't replace a Gary Bertier. That's corny. But the truth is that you can't replace Dan Rawlings. Everybody needs Dan Rawlings. And the question that it really boils down to today is, can there be a win-win in a lose-lose situation? Can a person who has committed misconduct to a level that he pled guilty to manslaughter still be released back to the community, given his life's work, given his tools, given his characteristics and background? And I stress that hard in our memorandum, that's part of your responsibility is to look at that characteristic, the back character and circumstances and background, because they're extraordinary to this person. Hundreds of people said so. Everybody agrees. So I'm asking the court to carefully analyze all that. It's quiet in here right now. I'm sitting next to a pretty amazing looking clock. It's a great big grandfather clock. And during the course of this proceeding, I hear it tick, I hear it tick, and I hear it tick seconds away. And Dan and I are sitting here wondering whether or not we're ticking away the time to the end of his good work, or with your grace, the beginning of the next chapter of good work. And I'm asking you to find that it should be the beginning, that there's a constructive way to find accountability and justice in this very unfortunate case. Last thing I'd like to tell you is that, counsel and I traveled down from the Flagstaff, Northern Arizona area today, and I stopped at the crossings. And there was as much peace and quiet there as there is in this courtroom today. And I'm hoping that instead of stirring it up, that we build on that peace, and we build on that mercy, and we build on the grace that was referred to by the witnesses. Because Dan Rawlings is one of the very few people in this extraordinarily unfortunate situation that deserves that opportunity. Thank you.
Thank you, Mr. Griffin. Let me say a few words before I get to the specific sentencing. This case is a tragedy, and by tragedy I don't mean accident. If you look up tragedy, it's something that causes suffering, destruction, and distress. And one of the things that's included in that is a crime. And it could clearly have been avoided by different actions by the defendants. In fact, really just one simple action of obeying a large road closed sign that was placed in the middle of the roadway. Without one other action, we're not here today. The defendant's actions, though, of disobeying that sign was not motivated by a need to get home or get to a store. They'd already done that. The only reason for attempting to cross the creek this time in the direction of away from where they were staying was that it was fun or entertaining to do so. As parents, we're held to a higher standard of care for our children and others in our care. Our children don't have the capacity or the ability to protect themselves. They need their parents to be parents and not their playmates. Thank you, Mark. I'll note you brought in Ms. Elledge's clients, and I apologize for not getting them. Thank you. There's nothing that can be done to bring back the 3 children who perished. There's nothing the court system done can really bring healing for their children, for these children or their families. One of the victims mentioned today that healing is sought in different and found in different venues than the courthouse. Jay Rawlings and Lauren Johnston have experienced loss like no parent should have to endure with the loss of their daughter. The four children who were fortunate and survived, they will suffer with the trauma of this event for the rest of their lives, and they will have and will continue to suffer the loss of their siblings and cousins. The extended family of the 7 children will continue to suffer, and 3 of the children will not be able to experience life. In the court system, we have 4 primary purposes for incarceration: public safety, rehabilitation, punishment, and the public recognition of the wrongfulness of one's actions. There seems to be really agreement among all the parties that public safety and rehabilitation would not be appropriate as purposes for incarceration in this case. These defendants do not appear to be an ongoing risk. They've been parenting 2 of these children in their home since this occurred. They don't appear to be a danger to the community at large, and I've not heard in any way that incarceration would be rehabilitative to them. The state has argued that the other 2 purposes, punishment and public recognition of the wrongfulness of one's actions, are appropriate, that the crimes committed by specifically Mr. Rawlings require both punishment and a public recognition of the wrongfulness of his actions. As I've considered this, I've struggled with the fact that regardless of the reason for any consequence or punishment, incarceration, anything I impose upon either defendant, incarceration, fines, community service, that punishment directly and adversely will affect 2 of the surviving victims, Dallin and Nellie, their children, and it may well indirectly affect the other 2 surviving children. Conversely, any leniency that the court were to show towards these defendants benefits the surviving victims, especially the 2 surviving children of the defendants. I suspect this factored into the victims' recommendations. As I'd heard from all of the victims' representatives of the children involved, that would be Jay Rawlings, Lauren Johnston, Ms. Elledge in her written pleading, and also from the 2 children today, all of them support probation and oppose incarceration. Under Arizona law, victims have a special status. Under the Constitution, our statutes, and the rules of criminal procedures, the court is required to consider recommendations made by victims. Any leniency that the court may exercise today should be in no way interpreted as minimizing the suffering, destruction, and distress that have been caused by these crimes, as minimizing the surviving children's pain and trauma, as minimizing Ms. Johnston's pain or Mr. J. Rawlings' pain, as minimizing the extended family's pain. I heard from an aunt and a grandmother this morning. Or especially minimizing or excusing this type of conduct. As I said before, we're here for one reason. These defendants failed their children. They failed to protect them. They failed to be adults who said no. And because of that, they pled to serious criminal charges. Conversely, again, any such leniency that the court may exercise today is, again, on behalf of the 4 of the surviving victims. These 4 children have 0 fault in the case, and yet they carry the burdens. With that, I'm going to move forward with Ms. Lacey Rawlings' sentencing. First, Ms. Mahady, can you move the microphone over towards your client, please? Ms. Rawlings, can you tell me your full true name?
Lacey Lynn Rawlings,
And what is your date of birth?
5/20/1987.
Court has previously accepted the plea. The court will now accept the terms of the plea agreements. It is the judgment of the court that you're guilty of the following crimes: amended count 1, child abuse as to CR, committed on or about November 29th, 2019, a class 4 felony. Amended count 2, child abuse as to AR, committed on or about November 29th, 2019, a class 4 felony. Amended count 3, child abuse as to WR, committed on or about November 29th, 2019, a class 4 felony. Amended count 4, child abuse as to SR, committed on or about November 29th, 2019, a class 4 felony. Amended count 5, child abuse as to DR, committed on or about November 29th of 2019, a class 4 felony. Amended count 6, child abuse as to NR, committed on or about November 29th, 2019, a class 4 felony. And amended count 7, child abuse as to LR, committed on or about November 29th, 2019, a class 4 felony. All of these offenses are non-dangerous, non-repetitive. As mentioned above, the court has read and considered the pleadings, the evidence and materials presented today, and the arguments of counsel. I'm going to find the following aggravators in this case: that there were multiple victims, that there was victim harm, physical, emotional, and financial, that at the time of the offense, the defendant was in a position of trust, that there was the presence of an accomplice, and also that she allowed the children to be transported in a vehicle without appropriate safety restraints. As far as mitigators, the court will find the following: that she has no prior criminal history, she's expressed profound remorse, she's accepted responsibility, she has familial responsibilities to the surviving victims, she has both family and community support, she's actively involved as a contributing member of her community, and she's a low risk. Considering all of these mitigators and aggravators, and again, all of the information provided, the court finds that probation is appropriate. It is the judgment of the court that imposition of sentence is suspended. The defendant will be placed on supervised probation for a period of 48 months in each of these matters. For each of these counts, the probationary periods will run concurrent to each other. Probation will date from today's date. I'm going to go over some of the terms of your probation. Before you leave today, we'll need you to sign for all of your terms. And Ms. Jorns, are you going to be writing those out as I go through them?
That's right.
Okay. As far as financial obligations, Mr. Seuss, you've indicated that you have not had a request for restitution.
I've not been made aware of any.
Okay. Let me ask Ms. Mahady if you have any objection if I leave restitution open for 30 days just so we can verify that there are no requests.
No, Your Honor.
Okay. I'll order that restitution remain open for up to 30 days. If there is restitution, it will be joint and several with Daniel Rawlings. I'll order a $20 time payment fee, $20 probation assessment, both the $13, $9, and $2 assessments, and the cost of prosecution. I'll order to make monthly payments on these amounts in the amount of $135 a month beginning February 15th and paid in full. There's a monthly probation service fee of $65 a month. That also will begin on February 15th. I'll order that you complete 480 hours of community restitution at the rate of at least 10 hours per month. I'll order that you actively participate in any counseling or assistance program as directed by probation at your own expense. I'll order that you not have contact with LR and SR without the expressed permission of both J. Rawlings and Lauren Johnston, and any contact with those two minors shall be under the circumstances expressly allowed by both of those parents. You're on probation for 7 Class 4 felonies. If you violate any terms of your probation, you can be brought back into court. If the violation is proven, your probation could be revoked. You could be resentenced for up to 1 year in jail on each of those. A fine of $150,000. Okay. And receive up to 3.75 years in the Department of Corrections on each count. Do you understand that?
Thank you.
You have the right to petition for post-conviction relief from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed to you. If you cannot afford copies of the necessary records and transcripts, they will also be provided to you at no cost. If you want to petition for post-conviction relief, you need to file a notice within 90 days of today's date, or you lose the right to seek that relief. You'll need to, you also have the right to apply to have your conviction set aside after you're discharged from probation. We'll need you to sign for a receipt of all your rights, and we'll also need to get some fingerprints from you after we're done today. Ms. Jorns, there was some reference to getting probation transferred potentially to Navajo County. Do I need to make any orders in that respect, or will she just need to contact probation? Okay, I'll direct that following court today, you report to the probation departments. If you have questions about where the building is, Ms. Jordan can provide that to you. I will try to point out which way it is. Basically, it's to the south and west, generally, of the courthouse. Ms. Mahady, anything further on your client? I'm going to ask her to remain seated, and she will do the paperwork after I'm done with Mr. Rawlings.
Thank you, Your Honor. Nothing further.
Mr. Seuss, anything further on Mr. Rawlings' matter?
No.
Now we'll move to Daniel Rawlings. Can you please tell me your full true name, sir?
Daniel Francis Rawlings,
What's your date of birth?
12/30/1993.
The court has previously accepted the plea. The court will now accept the terms of the plea agreements. It is the judgment of the court that you're guilty of count 1, manslaughter of the victim CR, committed on or about November 29th of 2019, a Class 2 felony. Count 2, manslaughter of the victim AR, committed on or about November 29th, 2019, a Class 2 felony. Count 3, manslaughter victim WR, committed on or about November 29th, 2019, a Class 2 felony. Count 4, child abuse as to CR, committed on or about November 29th, 2019, a Class 3 felony. Count 5, child abuse as to AR, committed on or about November 29th, 2019, a Class 3 felony. Count 6, child abuse as to WR, committed on or about November 29th, 2019, a Class 3 felony. Count 7, child abuse as to SR, committed on or about November 29th, 2019, a Class 3 felony. Count 8, child abuse as to DR, committed on or about November 29th, 2019, a Class 3 felony. Count 9, child abuse as to NR, committed on or about November 29th, 2019, a Class 3 felony. And count 10, child abuse as to LR, committed on or about November 29th, 2019, a Class 3 felony. All of these offenses are non-dangerous, non-repetitive. The court has reviewed the materials that I discussed earlier and the arguments of counsel and find the following aggravators: that there were multiple victims, that there was victim harm, both physical, emotional, and financial, that you are in a position of trust as to all of the victims, there was the presence of an accomplice, and you were operating a motor vehicle that was not equipped for the number of passengers, including the children, and none of the children appeared to have been properly restrained. As far as mitigators, the court will find that the defendant has no prior criminal convictions. He's expressed remorse and accepted responsibility. He has familial responsibilities to at least 2 of the victims. He has both family and community support. He's actively involved as a contributing member of his community. He's employed and he's low risk. The court has considered all of these mitigating factors and aggravators. The court has, well, as Mr. Seuss, I think, indicated, this has been a difficult decision for the courts. One that has been made with all of the information available and giving special consideration to the expressed desires of the victims in the case. Based upon that, the court finds that probation is appropriate in this matter. It is the judgment of the court that imposition of sentence is suspended. The defendant will be placed on supervised probation for a period of 60 months that will begin today. That's on each of the charges. The probationary periods will be concurrent with each other. I'm going to go over some of the terms of your probation before you leave. We'll need you to sign for all of your terms. I'll also direct that following today's hearing, you report to the probation office. Mr. Griffin, do you have any objection if I leave restitution open for 30 days as I did with the co-defendant?
No, sir.
I'll order that restitution remain open for 30 days. Any restitution amount will be joint and several with the co-defendant, Ms. Lacey Rawlings. And I'll order the following financial obligations: a $20 time payment fee, $20 probation assessment, a $13, $9, and $2 assessments, $750 to the cost of prosecution, a $50,000 fine, along with the $39,000 surcharge. Order that you make monthly payments of at least $435 a month on those obligations, beginning February 15th. There also is a monthly probation service fee of $65 a month. Additionally, I'll order that you complete 1,000 hours of community restitution at the rate of at least 20 hours per month. I'm not going to get into specifics as to what that community restitution will look like. Mr. Griffin has suggested one alternative with the little information you have. I don't know if that is a good idea or not, but that is something you could explore, or you can do it in your community. I'll order that you actively participate in any counseling or assistance program as directed by probation. That will be at your own expense. You're to have no contact with LR and SR without the express permission of J. Rawlings and Norman Johnston, and any such contact with those two minors would be under the circumstances expressly allowed by their parents. You've been convicted of 3 Class 2 felonies and 7 Class 4 felonies. If you violate any terms of probation, you could be brought back into court. If the violation is proven, your probation could be revoked. You could get up to 1 year in jail on each of the matters. Probation on the Class 2s could be extended to a total of 84 months. You could get an additional fine of up to $150,000 on each. You could get prison of up to 12 and a half years on each of the Class 2s and 8.75 years on each of the Class 3s. Do you understand that?
Yes, sir.
You have the right to petition for post-conviction relief from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed to you. If you cannot afford copies of the necessary records and transcripts, they will also be provided to you at no cost. If you want to petition for post-conviction relief, you will need to do so within 90 days of today's date, or you lose the right to seek that appeal. You also have the right to apply to have the conviction set aside after your discharge from probation. You need to sign for your review rights and also for your conditions of probation and provide us with the fingerprints. Mr. Griffin, anything further on that matter?
You can consider for transfer to that order.
Yes, and when you cease probation, the court has no objection to that. You just need to go through the paperwork with probation to make sure that works. Anything else, Mr. Griffin? Mr. Shoots, anything else?
No.
Okay. Then with that, we'll stand at recess. Defendants, if you can wait just a moment, I'll probably have Miss Lacey Rawlings come up first to see if the clerk will be ready for her to come up. If you can come on up, ma'am, and then, sir, after she's done, we'll have you come up. Miss Mahady, you can come up with me. It's the same language.
No, I'm not. Why do you think this is both kind of wireless general copy of all the I'll make sure I get those over you too.
Sheriff and Major Newman, if you guys, after I'm done here, if you have a minute or two just to talk about the case in jail. I saw an email this morning, just wanted to run that by you. Thank you.